Good morning, everyone. Thank you so much for attending the Estate Planning for Individuals and Small Business Owners. I'm John Amodio. I'm chairman of SCORE on Staten Island. We're very pleased to be able to put on this webinar. And I want to tell you a little bit about SCORE before we get to our tremendous speaker for the day. SCORE is an organization, it's a national organization that provides mentoring and education for individuals and small businesses. We're a bunch of experts, experienced people that are volunteering to give time in order to help organizations and individuals. This webinar is being presented by sponsorship from Richmond County Savings Bank. They have been very helpful to us in being able to bring some of this information to you, and we're very pleased to be working with them. Today, we have with us Annamarie Gentilly, who's an attorney and supervising partner at Angiuli and Gentilly. I've met Annamarie, I guess, 30 years ago when she was just coming out of elementary school.
Thank you, John.
And it's been a great relationship. If Annamarie, if you would move to the next slide, I'd appreciate it.
Sure.
Annamarie could tell you more about herself before she gets into the actual presentation, but I do want to tell you a couple of things, the logistics here. One, your line is going to be muted. I'm going to ask you to please use the Q&A instead of the chat so that we can answer your questions. We're going to leave the questions to be answered at the end of the webinar. So please write them down and send us to us so that we could then answer them for you. A copy of the slides are going to be sent to all the attendees after this program is over. And also you will receive a brief survey that will be sent to you. I would appreciate if you could complete that survey and return it to us at the end of the webinar. You'll probably receive the survey tomorrow and not immediately after this, or it might be immediately after this, depending on whether my person who's sending it is awake or asleep this morning. Okay, with that, let me ask Annamarie to please take over and stop you from having to listen to my boring talk. Take care.
Thank you, John. Well, thank you everyone for attending this morning. I took a quick look at the participants and I was happy to see some old friends there and also some clients. So to all of you, hello, hope all is going well. And to anyone who I don't know, I sure hope that what I'm going to speak about today will be helpful to some extent. John said briefly that I am a partner at Angiuli and Gentilly, a Staten Island law firm. We've been here on Staten Island, my partner Gary Angiuli and I, for the past 35 years or more, actually. My area of practice is elder law and estate planning. And today, because I know that some of you on the call are small business owners, we're going to add in at the end of the presentation some special information that could be helpful to estate planning in conjunction with having a small business. So just to give an idea of the presentation for today, we're going to be speaking about some basic estate planning documents that really all adults should have in place. We're going to speak about some techniques of estate planning to help get things in accordance with what your goals may be. We're going to talk about some issues that arise with regard to short-term and long-term care as we age, especially since people are living much older nowadays. It is becoming more prevalent that people at some certain points in time may need assistance with the activities of daily living. We definitely want to speak about protecting our assets in the event that we should become ill and need long-term care. We'll speak about some long-term care options. And as I said, we'll talk about some estate planning concerns for small business owners. As I'm going along, I'm going to try to touch on these topics, and later on, if anyone has specific questions, please definitely pose the questions in the Q&A, as John was stating, but also feel free to email me. You will have my email address, I'm sure, and I'll try to get back to you as well. Okay, so let's start with some basic documents that all adults, in my opinion, should have in place with regard to estate planning. And these documents that we'll start with are documents that help during your lifetime. Okay, so they are probably familiar to everyone, starting with the healthcare proxy. In the event that you are unable to take care of your own health-related decisions, you definitely want to have in place the legal document to appoint who may stand in your shoes. The alternative to having such a document could result in having to go into court to have someone appointed as your legal guardian. And of course, you always want to have who it is that you would choose to make your decisions. So with regard to health decisions, you want to put down at least one primary agent and an alternate. And this would be a person who would speak for you only if you're unable to communicate on your own. It could be for a temporary period of time, but it may also be permanent. And in any event, it will be a person who you've hopefully spoken with about your ideas with regard to healthcare, and that person will carry out your wishes for as long as you're unable to do so. The next document that goes hand in hand with the healthcare proxy is also going to help during life, and this is called a living will. This is an end-of-life directive. It's extremely important to have your wishes known in the event that you're at an end-of-life stage where, for example, the physicians say to your family members, well, the only way to keep your loved one alive is to now utilize various life-supporting machinery. You would want your agent on your healthcare proxy to know what your wishes would be in that regard. Number one, because it's important for the physicians to know if you're unable to express them. And number two, it does take a lot of the pressure and stress off of your loved ones, because no one wants to have to make that decision just, out of a clear blue sky. A living will is not a statutory document in the state of New York, but it is viewed as giving corroboration for wishes that your agent is saying you've made known to them. So we've had situations where, for example, if a person is in need of pain medication because they're at an end-of-life stage, oftentimes physicians who take the Hippocratic oath to keep people alive may feel that they're in a conflict if they give pain medication, which could, in some situations, hasten death. But when they see the living will where the individual expressed his or her own wishes, many times they're more apt to give the medication to make your loved one comfortable. So it is a very important document to have in your estate planning arsenal. The next document that also is going to help during life is the power of attorney. Now, I cannot express how important this document is. It is going to allow who you choose to stand in your shoes to make all decisions that you otherwise would be able to make if you were able to do so. And this is for everything other than health related. So if you were able to make decisions regarding financial issues, dealing with insurance companies, dealing with professionals like accountants, attorneys, dealing with the Social Security Administration, so many different things that only you can do. With the proper power of attorney, your agent is going to be able to do that for you. Again, I always suggest having at least one agent and one alternate, because we never know what can happen. And it's important when you do your documents to try to get as much out of the document as possible. You can have as many named alternates as you would like. Additionally, on a power of attorney, you may even choose to have more than one person on the same line of responsibility. And even further than that, you can choose whether those people must act together or whether they may act separately at any given time. So those are the documents that will be very helpful during your lifetime. As we get on to documents that could help once we pass on, the one that we're all familiar with is the last will and testament. This document is where you're going to express your wishes as to who your beneficiary should be when you die, of whatever assets you have when you do pass away. A will only controls what it is that you have when you pass away. And of course, those things are going to be changing over time. So oftentimes we don't put specifics in the will about specific bank accounts or specific investments, because we understand that over time these things are going to change. The thing about a last will and testament, in addition to stating who should get what, is that it names once again a fiduciary, a person in a position of responsibility, not only to you, but to your heirs. And this person is called the executor. So many people will say to me, well, if I have a will, we don't have to go through probate. But that's really not accurate, because if any assets are in the testator, that's the person who makes the will's name when he or she dies, and only in his or her name without any beneficiary designations, those assets are going to prompt the need for the will to go through probate, the process that typically occurs in surrogate's court in the county where the individual died a resident of. So a will, until it is approved by the surrogate in court, really doesn't have any value. So the probate process is something that can take time. It can be costly. As I say to my clients when they come in and we're speaking about some alternatives to a last will and testament, I say, honestly, the only winner in probate is the attorney, because attorneys are charging legal fees to probate wills. For the family members, not only is it an expense, but it's also could be training on what your role may be in having to gather documents and information for the court. And also it could take a very long period of time. So when we speak about estate planning, we also like to offer some other suggestions of what things can be done to avoid the probate process. And some of these things are going to include utilizing various kinds of titling of your assets. So naming things jointly, or putting a transfer on death, TOD, or payable on death, POD. These kinds of designations, by operation of law, will have the assets vest in the individuals upon the owner's death. And typically by showing a death certificate, the life insurance company or the bank or wherever the assets are held will release the funds to the beneficiaries. One of the things that's important to remember is that real estate cannot have a beneficiary designation on it. So if you own real estate, you're likely going to be facing a situation where if you have a last will and testament, your will is going to have to be probated. And now this is going to lead to another discussion, which is about utilizing trusts, either in addition to using a will or in lieu to having a will, because of the fact that the trust is going to avoid the probate process for any assets that are titled in the name of the trust. There are so many different types of trusts. We're going to touch on some general categories today, which are the revocable trust versus the irrevocable trust. So let's start with the revocable trust. With that kind of a trust, it is typically an identity of ownership to you yourself. The trust is going to use your own social security number. You are permitted and often encouraged to be the lifetime trustee of your trust. And you're going to be in full control of whatever assets you title in the trust. Now, it's very important to remember that when you do choose to utilize a trust of any kind, the next step is to title assets in that trust. Because if you go to an attorney's office and you prepare a trust and you never name your assets in the trust, so you don't go to the bank, for example, and give in a copy of your trust and say, all right, I want my bank account here to be titled in the name of my trust. If you never do that and nothing is titled in the name of the trust will not control anything. So you will have wasted your money in creating the trust, you'll have wasted your time, and more importantly, you may think that your estate is going to be handled simply without the need for probate. But if the assets weren't titled in the trust, now once again, the will is going to come into play. So when you're utilizing a revocable or revocable trust, you're going to want to make sure that whatever bank accounts or investments you have and whatever real estate you're looking to put in the trust formally are actually titled in the name of your trust. You, as I said, remain in full control of a revocable trust. You can change the provisions of the trust at any time, and your taxation of assets in the trust is going to be the same as taxation of your personal assets. You're not going to be filing a separate tax return for your revocable trust. Any income that's generated from assets that are in the trust will pass through to your own personal tax return. So the primary reason for utilizing a revocable trust is to avoid the probate process. When we have some additional concerns about not only simplifying the distribution of our estate, but of protecting assets in the event that we need long-term care going forward, a revocable trust is not going to give you any of the protection that might be needed for that purpose. The revocable trust, just to reiterate, is primarily used to avoid probate. But an irrevocable trust is the type of trust that will be utilized not only to avoid probate, it too will avoid probate, but it will also begin to protect assets that are titled in the trust from the cost of long-term care. So what do I mean about this? Well, when we're in a situation where we need to avail ourselves of assistance with activities of daily living, and this can be either at home in our own community, or it can be in an institutional setting like a nursing home. The way that we typically would pay for these kinds of caregiving scenarios would either be because, number one, we have long-term care insurance. Number two, we are going to pay out of pocket for this care. Or number three, we qualify for care under Medicaid. Now, I don't know who has done any research on long-term care, but if you haven't done any research, you may be saying, why is Annamarie speaking about Medicaid? Isn't Medicaid something that is for people who don't have any assets, who don't own a home, who don't have, investments and things like that? Well, when I'm speaking of Medicaid throughout our discussion today, I'm primarily speaking about a program that is intended for older adults and also for disabled people. And when we're speaking about it in terms of long-term care, we're speaking about it in conjunction with Medicare, which most people who are 65 years of age and older would be utilized, the Medicare, in conjunction with becoming eligible for Medicaid. And that is one of the things that we try to do when we're doing estate planning for individuals who have concerns about protecting their assets in this way. We try to lay the groundwork for eligibility in the event that in the future there does arise the need for long-term care. And when we utilize an irrevocable trust, we may not be our own trustee of the trust, okay? Because of the fact that in order for assets titled in an irrevocable trust to gain protected status, should we need to apply for long-term care, we have to distance ourselves from controlling those assets to the extent that the government says is acceptable to them to protect the assets that are titled in the trust. Now, when we begin to talk about protecting assets, the discussion is pretty much separated into two columns: real estate and financial assets, because those two different categories are treated differently when we speak about utilizing an irrevocable trust. So for the moment, let's remember that an irrevocable trust can function to protect our assets from the cost of long-term care, as well as to avoid the probate process. And you'll note on this slide something very important at the bottom, the asterisk, that says that there's currently a 5-year look-back period on transfers for institutional Medicaid. Well, that's something that's been in effect since 2006. So that's not anything new. But here is something new and very important. As of October 1st of last year, a new 30-month look-back period, okay, 2.5 years, was imposed on what we call the community Medicaid applications. This is for Medicaid coming to you at home to give you assistance with your activities of daily living. So you may know people who have the use of an aide coming to their own home, maybe 5 days a week, maybe 7 days a week, for 4 hours a day, 8 hours a day, or even more. And I wouldn't be surprised if many of those people are getting that assistance through what's called community Medicaid. So believe it or not, right amidst the pandemic last year in October, when I think we were trying to keep people out of hospitals and out of nursing homes, instead of making it easier for keeping people at home, the state of New York imposed a 2.5-year penalty transfer period on community Medicaid applications. Prior to October, believe it or not, if you took assets out of your name in any given month, as of the first of the following month, those assets would not be countable as assets in your application for community Medicaid, nor would they be reachable or lienable once care was instituted for you. But unfortunately, in October of last year, the legislature said, nope, at this point in time, if you make any transfers, you're going to have to wait for 2.5 years before those transfers will not impose a penalty on you in the event that you need long-term care at home. The good news, the bright point here, is that there was a grace period, which originally was only until the end of 2021. So what that means is that if you were on the brink of needing long-term care at home, or you knew of someone, perhaps parents or other loved ones, who were, teetering on that and hadn't pulled the trigger on it yet, as long as they made their transfers and filed an application by December 31st of 2021, the penalty period would not be imposed. So we had, as you could imagine, an influx of people wanting to take care of this so that they could get some community Medicaid in place before the penalty period would delay that. Well, luckily, that has now been further extended to April 1st. So it does give us a little breathing room for people who are interested in getting care coming to their home under community Medicaid. And this care is not just about getting an aid. The Medicaid component to the care, where you're dually eligible now for Medicare and Medicaid, will provide other things that Medicare doesn't cover. And these are things such as physical therapy and occupational therapy coming to the home, adult diapers, nutritional substitutes like Boost and Ensure, transportation in an ambulette to and from physician visits, so many things that are not covered under Medicare. Oh, even things like hearing aids, that people oftentimes just can't afford to get because Medicare won't pay for it. So the program is really a whole person review, and it's to enable people to age in their homes and not necessarily have to go to an institutional care setting, which I'm sure no one wants to voluntarily have to resort to. So the Irrevocable Trust is going to be very helpful in laying the groundwork to ultimately protect assets so that people can qualify for both home care through Medicaid and institutional care if the need is so severe. Let's see, what do we have here? The asset transfers. This is what we were speaking about with regard to the penalty periods. Just to reiterate, 5 years for institutional care and 2 years for 2.5 years for home care. The next slide is just going to talk a little bit about what types of long-term care are available. We have assisted living facilities. These are facilities where they're kind of an intermediary with people staying at home in their own home, as opposed to having to go into a skilled nursing home. And then, of course, the home care that we spoke about and the nursing home care. All of these things typically are paid for either out of pocket through long-term care insurance or through the Medicaid program. Now, the cost of care currently in our area for institutional care in our nursing homes here on Staten Island can be upwards of definitely $16,000 per month. I've had some individuals having to pay closer to $20,000 per month. Assisted living facilities can be, $10,000 a month or more, depending on the needs, because I found that although there are some base costs for living in an assisted living facility, it's kind of like an a la carte menu where, depending on what the individual's needs are, additional services will have to be paid for. Because I don't know if people are under the misconception that when you're in an assisted living facility, you're going to have an aide assigned to you, but it's really not that way. There are people there in the facility who assist in general with residents in the facilities, but they're not assigned to individual people. That's where you'll either be utilizing an aid through the community Medicaid program if you've been qualified for that, or you'll be paying out of pocket. That brings us to the next slide about financing short-term and long-term care. So we have Medicare, which covers for short-term home care or short-term rehab care. This is when, for example, you go into a hospital and maybe you had a surgical procedure or you had an illness and now you've been in bed for a long period of time. So you need some therapy to help you get back to getting out and about. Medicare will provide some short-term care, but it's very limited. It's going to be limited to the duration and also the number of hours of care, the number of days per week. So that is something that is just going to be there to help you get back on your feet. For long-term care, we're going to, as I said, either be paying out of pocket or purchasing long-term care insurance or qualifying for Medicaid for the long-term care needs that we may have. Just something brief to mention about long-term care insurance. I'm not an insurance agent, but I have been at seminars myself where insurance agents have spoken about long-term care insurance, and I've also had clients who have utilized long-term care insurance. In my view, it could be a component of your estate plan. I've rarely met anyone who has only implemented long-term care insurance and not a more comprehensive estate plan. The reason for that is because typically the cost of long-term care insurance could be very, very expensive, depending on how old an individual is when they purchase long-term care insurance, depending on the medical conditions of the individual, and also depending on the services that the individual elects to pay for. Because as with anything else, the more bells and whistles you have in the policy, the more costly it's going to be. So my experience with clients who've had long-term care insurance have been that they're typically limited either to duration. So maybe the policy will cover for a 3-year period or a 5-year period, or they're limited to dollar amount, overall dollar amount. Maybe the policy will pay out a maximum of $300,000 or something like that. Or they may be limited to a daily amount of payment for care. And typically long-term care insurance will cover both institutional care and home care settings or even assisted living settings. Now, there's something called an inflation rider, which when people purchase long-term care insurance, they can pay an additional portion of their premium to get a rider that will kind of help keep their daily rate that would be covered, help keep it in pace with inflation and the increasing cost of care, whether in a facility or whether services are coming to you at home. And then, of course, we have the Medicaid for long-term care purposes, which is typically what we as elder law attorneys are hoping to put into place for our clients when they come here with concerns about, what if I need to go in a nursing home? What if I need to have care coming to me at home? I don't want to lose everything that I work so hard for. I want to be able to pass on my home, maybe some assets to my children, my grandchildren, my friends who are close to me or my family members. So in order to do this effectively, the idea is to start as soon as possible. Now, it's never too early to start our estate planning, and it's certainly never too late to do it either. So one takeaway from today's talk might be to remember, if a loved one is suddenly in need of care, don't give up. Don't say, oh my gosh, we didn't do any planning, we're going to lose everything. That is not the case. Is it better to do planning in a non-emergency situation? Of course it is. But there is definitely hope to get some ability to save assets and to protect assets. So before you sign any applications or commit to anything, definitely speak to an elder law attorney And you're going to see that there are things that can be done even in a last-minute emergency situation. Now, just the slide that I have up right now, Medicaid, nursing home, or institutional care. So our benchmark of eligibility currently for both institutional and home care Medicaid, which we're going to get to in a second, is $15,900 in assets. Now you're probably saying, what does Annamarie have, rocks in her head? I wouldn't be a small business owner if I had only $15,900. So believe me, this benchmark is something that is doable, and that is why we create the planning, because the idea is that before the 5-year period or before the 2.5-year period, we want to try to transfer assets perhaps into the irrevocable trust or out of our names and into other scenarios, other names of individuals who we trust perhaps, in order to create eligibility in the event that we should need long-term care. Now, I do want to highlight that when we have a married couple and husband and wife are both alive and one is not already receiving services for long-term care, we have what's called spousal refusal in New York State. This is permitting an individual to legally refuse to be responsible for the medical expenses, including the exorbitant long-term care costs for their spouse in a nursing home or at home in a long-term care setting. This spousal refusal is coupled with oftentimes transferring assets from the well spouse to the institutional or the one who needs institutional care, that spouse. Because currently, believe it or not, that transfer is not subject to the 5-year look-back period, nor is it subject to the 2.5-year penalty period. So right now, we do still have that, I want to call it, gift of being able to transfer assets out of the ill spouse's name and into the well spouse's name. And with the utilization of spousal refusal, we're able to not have those assets count in the application of the ill spouse. So that all sounds great. So you might say, well, why then do we have to do anything, Annamarie? Why don't we just wait until, God forbid, one of us needs long-term care? And the reason why we encourage people to start earlier is because, first of all, we don't have a crystal ball. We don't know which spouse is going to need long-term care. We don't know if both spouses will need long-term care. And if that's the case, then we have nowhere to go. If one spouse is already receiving long-term care because we put the assets in the other's name, and now the other spouse needs long-term care. Well, if we didn't do any planning, now that other spouse is not going to be eligible, and that spouse is now going to have to spend down the assets that he or she worked hard to protect. So that is something that is very important and something that I wanted just to draw your attention to. The other thing, if we look at the home care slide now, the Medicaid, the community Medicaid home care, we spoke about the new look-back period, luckily in grace until April 1st of 2022. In addition to having the $15,900 maximum asset or resource allowance, when we're in a home care setting, we also have a mandate that to be eligible without having to pay into the system, an individual can only have a maximum of $884 in monthly income plus a $20 income disregard. So just over $900 a month of income in order to be eligible. So once again, people are going to be saying, well, I can't qualify because my income is, quite a bit over that amount. And that's where we have another, I'm going to use the terminology gift. This is the pooled income trust. What this allows us to do is to set up eligibility for community Medicaid for our clients who are over that income limit without losing the use of all of their monthly income, without them having to spend down or pay into the Medicaid program. And the way this is done is that we enroll our individual clients in a pooled income trust that's managed by a third-party administrator, which is sanctioned under the laws of the New York State Legislature, Medicaid, Human Resources Administration, and allow the individual's own excess income to be used to pay that individual's monthly expenses. I'm not going to go into this in any more detail because of our time constraints, but I'm more than happy to explain in detail to you all individually how this pooled income trust program works in conjunction with community Medicaid. And it's a wonderful way to be able to use your money to pay for your expenses, like your real estate taxes, your utilities, your groceries, everything that you're able to spend your own money on while still being eligible to have community Medicaid in the home. Okay, I'm going to skip over the long-term care insurance slide because I did touch on that a little bit. I also wanted to mention that when you're discussing community Medicaid, one of the concerns that people often have is, well, I don't want a stranger in my home. This is a very, of course, common concern, and it's understandable. And you may have seen on TV some commercials that talk about being able to have a family member be the caregiver and get paid for giving care to their mom, to their dad, to their aunt, their uncle, whoever the relative may be. This is definitely something that is available under the Community Medicaid program. And it's called the CDPAP program. It's a consumer-directed program, meaning that instead of the caregivers coming through an agency, they're going to be someone of your choosing if you're in this CDPAP program. You will be able to say, I want to use my daughter, or I would like my sister to be my caregiver. And your caregiver relative will get paid just as if they were employed at an agency. They don't have to have any special kind of training. They don't have to be, certified in any way. They just have to take a short online, I think it's maybe an hour or 90-minute course, and then they will be eligible to be your caregiver. The only person who cannot be the caregiver through this program is a spouse. So believe it or not, children can get paid for caring for their parents, but a husband or wife is not eligible to get paid for caring for his or her spouse. So all of this that we're speaking about, the home care component, is under what we call an MLTC model. This is managed long-term care. And again, it's where an individual is dually eligible for their health insurance, typically Medicare at the ages that we're speaking about, and in conjunction with Medicaid, because we've created the eligibility there. All right, so now I think what we'll do is we'll speak a little bit about some estate planning concerns for our business owner participants in today's webinar. So you may have heard of something called a buy-sell agreement. Buy-sell agreement is very important to a small business because what it does is it's an agreement that sets the parameters for the members of the business, the owners of the business, to not only talk about what should happen if one or more of the members passes away, but also if they get ill and are unable to work, or sometimes also when they're going to be in a position to retire. So in advance of chaos occurring and people, not having an idea of how they're going to buy out the other business owners, the buy-sell agreement can lay all of the groundwork for this. And it's very important because it'll talk about the role of family members of, let's say a deceased member of the business or a disabled member of the business. And all of these things will be provisions that are agreed to prior by the members of the business, as opposed to having, conflict at the time the scenario arises. And this greatly avoids the possibility of litigation, which is the last thing that you want when you've been in business with someone and now one or more of the members passes away and families have to be at odds with each other. So the buy-sell agreement is, in my opinion, really something to be examined by all small business owners when they're creating their business, and then of course revisited as things change in life. As we said, retirement, illness, death, all of these kinds of things will probably require looking at the agreement and seeing if any amendments are necessary. One of the other things about a buy-sell agreement is that it's oftentimes utilized in conjunction with insurance policies, because the life insurance on the individuals who are owners of the business is many times the way that the interest of the deceased partners, family members get paid, or how people are paid in retirement or disability or things of that nature. So many times attorneys are working in conjunction with the financial advisors of the members of the business or their CPAs as well. So those are some very important things to keep in mind, but buy-sell agreements are really invaluable when it comes to small businesses. The next slide that I have here, and I do believe it's pretty much the last substantive slide, is going to talk about limited liability companies, LLCs, versus utilizing irrevocable trusts for small business owners. So an LLC is a legal entity that is a corporation of sorts. We call the participants members. We don't call them shareholders. And it can be a single member LLC, meaning that really it's a sole proprietor of the business, or it can be a multi-member LLC, any number of members of this business who are going to be at the helm. And the primary purpose of utilizing an LLC is to protect against liability of assets that the particular business has. And the way this works is that the company itself, the LLC, is only vulnerable for the assets in that LLC, so that if they're sued, either because of a disgruntled consumer, let's say, or somebody has an accident on the property of the LLC, the only asset that is at risk would be the property that is the LLC or the business that is the LLC. And of course, you are going to have your liability insurance, definitely. But sometimes if damages are catastrophic, the insurance is not enough to cover what the claim is, or even worse, what a judgment may be. So limiting the exposure of the individual members of the LLC to just whatever is in that one company is very, very important. So your personal assets, let's say your house, your investments that you have as an individual, your vacation home, things like that would not be up for grabs as a business owner in the event that you were sued, but your holding of the business was in an LLC. So that is definitely an important reason to utilize an LLC. There are also, as I understand from my CPA friends, tax benefits to utilizing LLCs. I understand that it is a pass-through type of arrangement where the income and losses pass through to the individual members. So again, not requiring, just like with an irrevocable trust, a separate tax return. And oftentimes corporations or trusts are taxed at higher rates than individuals. So this is a tax benefit of utilizing an LLC, having the profits taxed only at your personal rate. Right here, an LLC tip: if you own multiple properties or you have multiple businesses, you never want to utilize one LLC as an umbrella. You want to have separate LLCs for separate properties and separate ownerships, because again, the goal is to just minimize exposure to whatever assets are in that one LLC. Believe it or not, many people come into me and they think that having an LLC is going to avoid the probate process. It does not avoid the probate process, everyone. Ownership in an LLC is just like owning shares of a corporation or having a monetary interest in an investment account. It has to go through the probate process. So we oftentimes create trusts and we convey the LLC interest into the trust, so that not only are they sheltering their exposure, their liability, their exposure for liability, but also for the business owners, we're creating an avoidance of probate because we're utilizing the trust in conjunction with the LLCs. The advantages of using an irrevocable trust to the LLC are that the irrevocable trust, which also offers the asset protection for any assets titled in the irrevocable trust for the individual, it is going to avoid probate. So that is the primary benefit of utilizing the irrevocable trust. They have also the benefit when utilizing the irrevocable trust of the pass-through for taxation to the individual, being taxed at the individual's tax rate. The irrevocable trust disadvantage is that you are going to lose, I should say, some degree of control when you title certain things in an irrevocable trust. And many people do not want to give up control, especially when they're speaking about a business. So, you know, this is not a perfect science. It's not something where we can say, well, if we do 1 through 10, we're going to protect everything. We're never going to have to pay any money out for long-term care, and everything is going to be simple for our loved ones. But the idea of it is these are options that are available to you, and you're going to choose what makes the best sense for you, depending on what your long-term goals are. So I think that I've kind of covered everything that I was hoping to cover today. I can't stress enough that everyone's estate planning should be tailored to your own individual needs. If you do nothing, it's potentially going to be more expensive for you and more burdensome for your family. And it's an evolving situation. You can always alter your estate planning, and you should alter your estate planning as things occur in your life, or also as the laws change and you need to be updated about the laws. So we here at Angiuli and Gentilly are more than happy to offer to all of you participants today a free consultation to meet with me about discussing your own estate planning goals, to review some documents you may already have in place, and to let you know if everything is in order or some suggestions about what you may want to consider. So, John, I think I've spoken enough. They probably are tired of hearing my voice, but maybe there are some questions. I think you're on mute, John.
Yes, there are a few questions.
Okay.
Let me go through them. First is, should assets in a 401k or TDA be included in a trust?
Okay, that's a great question. Thank you, whoever asked that one. Remember that what we've been speaking about today is really tailored to New York State residents, because every state is going to have different rules and regulations about the treatment of assets and about the particular planning that is required to get the best benefit of protecting assets. In New York State, we are so fortunate that retirement assets that are in payout status. So these are things like 401ks, IRAs, 403bs for a lot of our healthcare workers, 457s, even thrift savings plans, TDAs, all of these pre-tax retirement investments. Once we put them into payout status, they are, number one, exempt from consideration for eligibility for long-term care through Medicaid, and they are not reachable or lienable to be recovered even after the person dies for the cost of care that was given on behalf of that individual. So what has to happen is, before applying for Medicaid, if those assets are not already in payout status, they must be put into payout status, which is going to shelter that whole principal value. And only the RMDs, required minimum distributions, will be vulnerable to the cost of long-term care as a component of income, not as an asset or resource.
Okay, thank you. In line with that, there's also a question here that is, if you live in New York City and then move to another state, say Florida, does the trust stay sound, or does it have to be redone in the new state?
Yep. So that question is also very common and a good question, because so many people nowadays are, moving, and what you think today may not be where you think you're going to end up in a few years from now. So the answer to that question is that as long as estate planning documents are properly done in whatever state they're prepared in and properly executed, they are going to be given full faith and credit in all 50 states of the US. So the short answer is, there is no need to redo your estate planning documents from a legal perspective if you move to another state. One of the things I would point out, though, is that it's not a bad idea, if you do move to another state, to eventually have your documents looked at by a practicing elder law attorney in that state, because there may be additional documents that, let's say, we don't utilize typically here in New York that are common in the other state. So you may want to add different things to, your package of estate planning.
Thank you. There's a question that says, when you say assets titled in a trust, what does that mean? Named, identified, or do the actual titles of property need to be redone?
Yes, very, very good question. When I utilize the terminology titled in the trust, I mean that the name on the asset, whether it's, let's say, start with a bank account, a regular bank account, instead of it saying, Annamarie Gentilly on the bank account, it's going to say the Annamarie Gentilly Irrevocable Trust. or the Annamarie Gentilly Revocable Trust. If it's real estate, the deed is going to have to be changed from Annamarie Gentilly to the Annamarie Gentilly Revocable or the Annamarie Gentilly Irrevocable Trust. And when we're speaking about real estate, we will actually prepare the new deed and transfer documents to complete the conveyance into the new trust. And there will not be any transfer taxes incurred because money isn't changing hands, but retitling is occurring, and the county clerk's office requires us to prepare the same transfer documents going from individual to trust.
Annamarie, a lot of people have accounts in the name of, for example, let's say Annamarie Gentilly has an account in Trust for John Amodio.
Mm-hmm.
Where does that fall in the categories here? Is that a revocable trust, irrevocable trust,
Okay.
no trust?
So yeah, I mean, for what we've been discussing today, it doesn't fall in any of the category, in either category, I should say, of revocable or irrevocable. But what it means is that if Annamarie does nothing and she dies, and the account said in trust for John Amodio, it means that by operation of law, at the moment of Annamarie's death, those assets vested in John Amodio. So now John is just going to be able to show the death certificate to the bank, and they're going to, issue a check to John Amodio. Now, that in a way is a form of a revocable trust designation, but not in terms of what we were speaking about necessarily, because this is a particular asset with an individual trust designation. Very importantly, we have to keep in mind that an individual who leaves assets in trust for somebody, just like you were asking, is simplifying the passing of those assets without the need for going through probate. However, very importantly, is not protecting any of those assets during their lifetime. So if that same Annamarie during her life needs to go into a nursing home, even though the account says in trust for John Amodio, it's treated 100% as Annamarie's asset and will have to be spent toward the cost of long-term care. So putting it in trust for designation, even putting a joint owner like Annamarie and John Amodio, owners of that bank account, is not going to protect those assets in the event that either Annamarie or John Amodio should need long-term care.
Okay, thank you.
You're welcome.
A question comes up as to what's a typical cost or fee for setting up irrevocable trusts?
Mm-hmm. So, I know everyone wants to know this, and I'm going to try to answer the question as best as possible. Setting up an irrevocable trust is one component of the estate plan that we spoke about. So I would encourage people to consider meeting with us or any elder law attorney to talk about the complete plan that would work best for that individual, depending on their individual needs. And at least in our office, the way that we handle these kinds of things is that we do give more of like a package kind of treatment for when people are doing things as part of a comprehensive plan, as opposed to just doing a trust. But because I know people really want to know what these things cost, I say that you're welcome to come in and I will sit with you and give you exactly what it's going to cost you once I know what your situation is and what your needs are. And that's why we offer to our clients the free consultation. So really you're not losing anything except a little time of your own. But just to kind of answer the question, and give you some idea of the range, you're probably talking of something anywhere, beginning maybe at, $3,500. And for some people, honestly, going up to $10,000. It's really going to depend what that individual's needs are. Is it a couple? Do they need specialized trust within their trusts and things of that nature?
Thank you.
You're welcome.
The question that's been posed to me a number of times is the question of a divorce.
Mm.
And what effect does divorce have on Social Security benefits and wills? People say, hey, you must include your spouse
Yes.
all the time, and it's a divorce automatically stop that from happening, or the like.
Okay, so the one mandate when it comes to leaving assets to anybody is that if you are a married person, there's what we call the spouse's right of election. What that means is that even if a married person tries to cut out their spouse from inheriting assets, the spouse who is cut out, if they're married at the time of death of the first one to die, is entitled to an elective share of the deceased spouse's estate. And the elective share amounts to 1/3 of the value of the estate of the individual who dies, or of what we call testamentary substitutes. Things that are like life insurance that was set up by the testator, or other things that function in lieu of something passing through a will, but are going to be distributions to people upon death of that first spouse to die. So we must understand that a spouse can make the claim for the 1/3 right of election. If people get divorced, then all bets are off. And once you're divorced, there is no mandate to leave anything to the former spouse. Now, had you created wills when you were a married couple, by operation of the divorce, and this is typically going to be in the divorce judgment and in the divorce settlement agreement, but even under the law, without any of that, it says that wills that left whatever to spouses of the testator, once divorced, are not going to be effective. So the former spouse, just because you never changed your will, is not going to inherit under the old will. But this brings about an important topic, which is it's one of the reasons to consult with your elder law attorney if you get divorced, because then you definitely want to revisit your documents and now provide for whomever it is who you want to provide for.
Also, in line with divorces or marriages, how does the same-sex marriages fall into play here?
Yeah, the rules are the same exact as they are for traditional couples. So we, have done estate planning for, the gay and lesbian community, and their concerns are the same as for the heterosexual unions. You want to provide for your loved one, and as long as the marriage was legal in the state, these rules that we discussed today are going to be applicable even to those couples. Also, there is the ability to utilize the domestic partnerships. People come into me with these things sometimes, which do not take the place of being married. So it doesn't entitle to anyone. It doesn't entitle anyone to benefiting as a spouse under the laws of distribution, but it does have certain assistance when we talk about long-term care planning and the medical aspects of things.
Okay. Also, Annamarie, you mentioned the spousal refusal. And is there any such provision for child refusal?
So a child is not legally required to pay for the expenses of the parent, even if they're medical expenses. What's important to remember, because many times the person taking care of an elderly parent is the child. And so they may be the one accompanying the parent to the nursing home when they're transferred from a hospital to a nursing home, and they're overwhelmed with all paperwork and things that the facility wants to be signed. And the important thing to remember as a child is do not sign anything that obligates you personally to pay for the care of your parent. Because if you don't sign anything as a child, you're not going to be legally obligated. What we tell our clients in those scenarios is be upfront with the facility and say, I'm going to take these papers to my attorney and have my attorney review them before I sign anything, to make sure that it's appropriate. And the facilities, I haven't run into a problem with that. They understand.
Okay, I think there's two more questions and then we'll end it for today. Is the irrevocable trust preferred over spousal trust?
Is the irrevocable trust preferred over a spousal trust? Okay. I'm not exactly sure what the person asking the question is referring to when they say a spousal trust. I can say that the irrevocable trust, aside from literally taking your name off of an asset and putting it in someone else's name, which we do not recommend. Now, obviously, between spouses, we're talking about something different. The reason why we would transfer assets to a spouse out of the other spouse's name and not into an irrevocable trust is in an emergency situation where one spouse is now in need of care immediately. So we want to get the benefit of not having any look back period on that transfer. That's why we would transfer to the spouse. But barring that, in a calm situation, we want to use the irrevocable trust because we want to have a scenario where we're ultimately protecting for both of the spouses, should both of them need long-term care. And in terms of the vulnerability of those funds that are in need of being protected, the only way to do it safely, in my opinion, is to put it into this trust, because it doesn't vest in any individual until the death of both of the spouses. So if we instead put the house, let's say, in the children's names, and something happens in the kids' lives, and someone sues the kids, and they get a huge judgment against the kids, now that judgment can be put as a lien against the parents' property. So we don't typically recommend putting other people on the assets. We typically are much more encouraging of using the irrevocable trust. Another reason to use it, and I didn't get a chance to mention, the tax treatment upon the death of the parents is so favorable to assets in the irrevocable trust because the heirs get what we call a step up in basis to the date of death value. So this includes not only real estate in the trust, but also financial assets that have appreciated. So what it means is, let's say the parent paid $50,000 for their house that's now worth $1 million, which is so common here on Staten Island. When the parent dies, the second parent to die, whatever that property is valued at that time, $1 million, is going to be the starting point for the beneficiaries. So when they sell that house, they're not going to have a capital gain calculation going back to what mom and dad had paid for the house. Whereas if we just put it in the kids' names, they're going to get their parents' cost basis and they're going to have $1 million capital gain.
Okay. The last question is, What information would I need to bring to have a consultation? Or what materials do I need to gather in order to work with an attorney?
Mhm. Well, for the initial consultation, I would say the most important documents to bring would be any existing estate planning documents. Okay, so any wills, trusts, powers of attorney, healthcare proxies. And also, if they have easy access to current statements of their assets, like the bank account statement or the brokerage account statement. The reason why I not need, but I may like to look at that is not necessarily the amount of money, because the people can certainly just tell me that, but I like to see the titling of the assets, because sometimes people will think that they have a joint account with their daughter or their son, and that's not the way the statement is reading, So current statements and present documents. In terms of deeds, we can pull deeds in the New York State registries. So you don't, if people don't have that handy, we can just pull that while they're here. But if there are any deeds to out-of-state properties, it would be helpful if they could bring it in.
Okay. We've gone way beyond the time limit here, but people who haven't had their questions answered, maybe we could arrange that they could give you a call or call us at the SCORE.
Absolutely.
And
Yeah.
we'll be able to, we'll try to answer their question. Okay. If you could, Annamarie, just come to the last slide for just a second.
Absolutely, John. Let me get down there. There you go.
Okay. You're going to receive the slides in a package. And the last slide, just as this one says, is it's really thanking you for attending today. We really appreciate you being a part of it. Gives you a little bit of information about SCORE, and it tells you how to reach us. The reason I want you to know how to reach us is if we could help in any way with answering any of your further questions that you might have on this issue, or putting you in touch with someone who could answer your questions. You have the information to do so. With that, I just would like to say thank you to everybody for being here today. Thank you, Annamarie, for such a terrific job that you've done. And with that, goodbye, everyone.
Thank you very much, everyone. Happy Thanksgiving.